Are you in the middle enough?
Hello everybody. So I'm hoping we're just on time at 3 o'clock. I'm pleased to say we've got some more people joining us as we go along, which is great. So thank you everybody for joining us today. We will just kick off very quickly with a sort of hello and an introduction to Cummings Pepperdine and to Serena and me. So first of all, thank you for everybody for coming. And for those who don't know, Serena and I are with Cummings Pepperdine. And as it says towards the back of the slides that you're about to see, Cummings Pepperdine is a quite unique service, and that what we do is we offer people advice on what we regard as the three key areas, the three key pillars of business in this arena. So law, FCA, and tax. We haven't got our tax or accounting team in today. It's me and Serena. My name is Claire Cummings, and I'm the managing partner at Cummings Pepperdine, and I've been a solicitor working in the world of financial regulation, hedge funds, and crypto for the last 20 years. So obviously not quite that long with crypto. And if I could pass over to my colleague, Serena Joseph. Serena will tell you a bit about her as well.
I'm a regulatory specialist. I specialise in governance and risk and compliance in both PRA and FCA, but today I'm focusing on the FCA. I advise clients on getting authorised, staying out of trouble once they are authorised, and navigating that unwelcome place of enforcement if they get into some trouble, so they can get out as unscathed as possible from the process.
Yes.
So Claire and I quite regularly team up on client assignments, bringing different skills to bear, but our intent is to give you very practical and pragmatic advice about navigating, handling the regulator, and making sure your business can run in a manner that they will consider compliant should they come looking at it.
Yeah, and I should say that what we try to do is we do like to work with people before they get into trouble. So yeah, as with doctors. Now, let's kick off. If I could give you a horror story. I don't know if anybody saw, let me go on to this website. I don't know if you saw my post on LinkedIn yesterday. I don't think, let me how to put this. I think that everybody who deals with money laundering, whether it's crypto or not, and it's called money laundering, not crypto laundering, should be very aware that of where dirty money comes from and what is done with it. I was speaking yesterday to Rob Moore, who's the head of intelligence at Mitmark, about a client we've got, and he gave me this quote. Is it just be very aware that the money involved in scams and money laundering doesn't do nice things. It's human trafficking, prostitution, child pornography, as well as the North Korean nuclear missile program sometimes. So it can go to nasty places. And I do say it's money laundering, not crypto laundering, because money is there as well. Now, let me just tell you a quick story about the matter that Rob and I are working on at the moment. And I'll tell you this story because some of you are here because you are regulated. Some of you are here because you don't need to be, but you want to adhere to regulatory standards. And some of you are here because you're interested in making crypto investments yourself. And I'd like to tell you the story as a precursor to then showing you sort of what to do wherever you are on whatever side of a trade you are. I have a client, and I'm going to call him Adrian. It's not his name, but it's my brother's name, and I quite like to wind my brother up. Adrian is a financial services professional. He's been trading the markets now for 20 years, and he's done extremely well for himself. Before Christmas, he decided that he would put about £500,000 into crypto. He went into an exchange which was regulated in Malta as a VASP, a virtual, with slightly different wording to we've got here, but regulated in Malta. He then sent the money from the wallet with the exchange into somebody else who said they were running an algo and would make him lots of money. At that point, the money actually disappeared completely. So the money's has now become proceeds of crime. That money has completely gone. He's been getting all sorts of phone calls, emails, whatever, saying, well, we need to get more money from you to be able to give this back to you. Adrian is by no means a simpleton. Adrian, as I said, is a multilingual financial professional, trading for 20 years and been hugely successful. But the scammers are so clever that actually they don't just look out for everybody. These scammers look out for everybody. So it's not. Please don't think that because you're financially sophisticated, you're safe from this. Sadly, that's not the case. So that is the story of Adrian, and his money is now gone. We're working with MIT Mark and also with 36 commercial barristers set to track the money, which we have done, and we know where it's gone to. We know now that it's with a combination of this money is now being held by money launderers who are in North Korea and Russia, and they've got the money, but we think we know where it is, so we can then get a freezing order, hopefully get the money back. So that is why I have said, do you really, or pose the question, do you want to finance human trafficking? Do you want to finance the North Korean missile program? Do you want to finance the most ugly, terrible things that can ruin the lives of children? If not, take note. As I said, this is for people who are FCA authorized, those who aren't FCA authorized, those who want to invest in crypto. This is how hopefully will keep you safe. So what is money laundering, first of all? There we are. Well, money laundering is, as you might expect, a criminal offence. And money laundering is since I'm trying to get more people into the lobby, money laundering is not just in money laundering regulation, it's also covered by the proceeds of crime. And I've divided up here into two areas. First of all, this is what the launderers do, the process of overt money laundering. And the second is what you need to be careful that you don't do, which is failing to look at what's going on and then report any suspicions you have. So also consider the proceeds of crime. Now, if you're regulated, there are two areas which are the most important. There's one piece of legislation, rather, which is the most important for you. And this is these are the money laundering regulations of 2017. They combine both the 4th money laundering directive and the 5th money laundering directive in one place. And if you Google what that citation, then you'll be able to find them if you really want to go searching through legislation. But also have a look at the FCA handbook. Consider whether you are somebody who needs to be registered by the FCA if you're a crypto asset business. Consider if you're somebody who needs to be authorized because you are carrying out a regulated activity with a regulated type of investment. And even if you're not, look at the rest. I say it's worth looking at the FCA handbook and making sure that you adhere as much as possible to those rules, because it's a way of keeping you safe. Now, when I mentioned whether or not you need to be regulated by authorized by the FCA, the people who need to be registered by the FCA, those who carry on certain types of business with crypto assets. As the first question that poses, well, what actually is a crypto asset? There isn't really any fixed definition of this. There's a European regulation, there's a Treasury definition, there's even a Bank of England definition. The one we're using here is the FCA definition, and it's nothing which is going to be unsurprising to anybody. Cryptographically secured digital representations of value or rights, which use distributed ledger and can be transferred, stored or traded electronically. And remember, it includes right to assets as well. It's not just the asset. And the two types of crypto asset business which you need to be registered for the FCA are crypto assets exchange providers and crypto asset wallet providers. Now, I don't want to spend a lot of time going into what those are here, but really they're fairly much what they say they are. So a crypto asset exchange provider is somebody where you can put the money into, take your fiat, and it will be turned into crypto for you. And if you remember back to my war story about Adrian, the financial professional who got scammed out of £500,000, his entry into crypto was by a crypto exchange, but it was one that was regulated by a European regulator. It was afterwards it went wrong. And then the second lot of people who need to be defined are once you have got your assets sorted out, and then now your fiat has become crypto, it needs to be held somewhere, and it will generally be held in a type of wallet. So those people who are wallet providers, so in effect, I tend to think of them as sort of a type of custodian. They need to be regulated as well. Poor Adrian in my war story, he used a regulated exchange provider, but then went and stuck all his money into a wallet which wasn't regulated. Had he carried out checks on the wallet provider before he sent his money in, thinking that the algo would make him even more money, he would have realized they weren't regulated, and I think probably have had second thoughts. So anybody out there who wants to invest in crypto, just don't do anything other than through somebody regulated. And if you're not certain, you want somebody to check out the bona fide nature, get in touch with us and we can certainly help you with that ourselves, or if necessary, we can get in somebody like Mitmark or Chainalysis, whom we know to help you with that. I did also mention, this is worth quickly going through, I also mentioned people who are authorised as well as registered. And I mentioned people who carry out regulated activities with regulated investments. Now this, as I say, is a two-limb test, and it goes back to section 19 of FISMA. Sorry to bring in too much legislation. But if you are carrying out something like advising, arranging investment management, certain types of custody, in relation to certain types of investment, and if this may include what the FCA term a utility token, we need to think about whether a security token is regulated as well, and that's sort of another one to think about another day. But just bear in mind that you may need to be regulated by the FCA under FISMA as well, and be authorised as well as being registered under the money laundering regulations. And then finally, just to give you a few links before I hand over to Serena to go through the practical aspects of everything I've been yakking on about. If you want to have a look at the rules and regulations and see what it is you need to consider and how you can use them to help protect your business, whether you're regulated or not, here they all are. Obviously, the money laundering regulations are legally enforceable, as is the FCA handbook. The Joint Money Laundering Steering Group guidance isn't enforceable, but the FCA have come out and said that if you abide by their guidance, then they will take this as evidence of compliance. I don't think they've updated it for Brexit yet. That still needs doing, but it is a very, very useful document and use guidance to have. Now, I will step away now and ask Serena to start to take the legal aspects I've talked about in the legislation and describe to you how you can, in a practical sense, put everything in, put everything in. Yeah, sorry, Neil, yeah, I did mention, I think with the fourth, and then we've got the fifth money laundering regs all combined into the fourth and fifth anti-money laundering directives are all combined. So thank you for that comment quickly. So Serena is going to be a bit more practical. So I'm going to stop going on about the background and the legal framework and ask Serena to.
So where we start, and it's not really a surprise, because I'm sure a lot of you from FS or you've followed a lot of the exciting news like Credit Suisse about what's been happening with anti-money laundering. But where do you actually start? And when you're sitting in a firm, even if it's a very small firm and you think, do we need to worry about this? The real starting point is you have to protect yourself and the firm. from being accused of money laundering, terrorist financing. You could go further, you could say tax evasion, and you can look at it very much from the who do we have in our customer base? Who do we have in our connections, in our business connections? Do we know who we're dealing with? And that will help you start the starting point of working out your own exposure to money laundering and potentially to terrorist financing. And you will need to follow both a governance process of setting up an understanding from the top down. So you've got a pyramid from your board or leadership team. And if you're really, really tiny, just the two founding partners potentially, to work out what it is you are going to put down as your stance for the policies. A lot of people start with a no tolerance, adhering to the UK regulations, following the spirit and the principles of JMLSG, which FCA has adopted. Yeah, even if you're sitting outside or in the perimeter of the regime, I think those are quite good starting points for protecting yourself as an individual and protecting the business.
Yeah, and I think it's probably worth just pointing out here that the reason we've put here at the top, these are the four key obligations. We're going to go through each one each in more detail. The reason we put assess your own exposure is because this is the starting point, and we'll describe what you need to assess. But everything else goes back to this. You need to assess, reassess, continually assess. And then everything you do after that, the policies, the KYC and records, are pinned back to what you have assessed to be your risk. And this is because it is a risk-based approach that the FCA takes. You look at your characteristics, assess your own risk, and work from there.
And you probably do a lot of it intuitively, that you actually you almost don't know where to start because you're so used to thinking about it. So the key criteria that we've got to deal with when we're talking to a regulator or we're talking to an investigation, a crime force that are asking how we got into a situation or how we avoided getting into a situation of handling a client. So you've got to take appropriate steps. Now, that means all sorts of things to different firms. If you're a small firm, it will be reasonable steps and careful precautions. But for everybody, regardless of the scale of the business, it will be that you have a risk appetite statement. A non-tolerance one is probably where we'd recommend, but you have processes and policies, and that your staff, if you've got staff, are able to follow those to identify and assess money laundering, terrorist financing risks that you're exposed to, and that you think about your end-to-end product governance, your customer base, your territories of operation, the sort of customers you might obviously attract, and the sort of customers who might be linked to your customers, who it may not occur to you might be part of a business partnership or a trading relationship or even a personal relation to somebody who is going to be either vulnerable or actually conduct money laundering.
Yeah, and we do actually, I think we'll see when we come on to it, we do talk about where you also need to consider the counterpart to any trade that you or your clients are part of as well. So it's fairly wide reaching.
So take those very, very simple process maps of how you do your business, who your customers are, where you're trading, what your products are, and think about those. I personally find the JMLSG stuff much more accessible than the FCA because it's sort of very practical and it's got lots of guides and you can work out what you're going to do about your own tick lists on the back of that. And from your risk assessment, work out where your risks lie, who's going to be in charge of sorting it out. If you don't need a formal MLRO, it's still worth having somebody nominated to be accountable for checking how you are dealing with the risks of money laundering, even if you're not formally caught, so that as you come through into a more regulated marketplace, and in fact, Neil's already made that point, that there's this creeping scope of capture that from the 4th to the 5th money laundering regulation into the FCA's enhanced 2019 requirements, you've got this sort of, oh, and we'll add in this sort of area, we'll add in this subsector. Oh, let's think about that. And crypto is very much a thing of the moment. And I think the risk here is that you're suddenly going to find that the mood music has changed. FCA go, oh, actually, from a consumer perspective, separate from whether you have to be FCA regulated, but with the consumer duty perspective, we're going to worry about this. And suddenly you're inside a regime, even if you're not actually officially caught with the FCA authorization regulated activities order.
Yeah, and if I could just quickly say on the point about who you have to appoint internally, we're going to come on to that a bit when we look at sort of you know, how you deal with internally. But also, if you just look at the last bullet point on this side, keep your risk assessment and all the information up to date and on hand, because if you are regulated, the FCA can come in at any time, spot check, and they will want to know that you've got everything there. We'll touch on this a bit later, but it's so key because you could be in trouble if you don't have it in place. So that's my little word, my legal risk warning to add to Serena's practicalities.
So really on the second point, the sort of, put in place the necessary policies, controls and procedures. What have you actually got to do? Well, let's work out what you need to assess. And this is a common sense piece. So you need to think about who your customers are, where are they operating, which territories. If you've got dual nationals, you have to think about the other passport from the one they might have offered you, which sounds quite strange and it may not be very intuitive. You have to work out how to manage communicating to the customer to point out that you'd like to know about the second nationality they hold, the alternative passport. And then you've got to think about your products and services, but you've not got to think about them from I'm trying to sell these services. You've got to think about it in a cops and robbers perspective. You've got to think about how do they break it? How do they get what they want from what I'm trying to offer? How do we have vulnerabilities? Is there something through the APIs we're using? Is there something through the territories we're domiciled in or trading in? That means that we've got a vulnerability we hadn't really thought about, but somebody else, it's a golden opportunity.
Yeah, and I think when we talk about third countries, there are lists of countries that fat for have, please don't deal with them. And I think, just think about today in Ukraine and the sanctions. It's changing all the time, but always check those third countries. And there are specific rules dealing with third countries. Again, that's a slightly more legal element, so I will shut up.
But you'll also find that in the GMLSG guidance. So it's thinking about your risk and think about your delivery channels and where somebody could, in a sense, hijack what you're offering and use it for their own ends. And your care doesn't really stop there. When you're doing the assessment, you need to write down what you're assessing. You need to write down the process you've gone through of working out where your risks sit. You don't have to do it in a technical way. You can do it in an Excel spreadsheet if you're small. You can have a Word document. It can go to your very small partnership or director limited board. But what you need to do is you need to create an audit trail of evidence so that if somebody was to come back, and it could be the crime investigation authorities equally as the FCA, you're able to evidence that you'd thought about it and you were doing your best to manage it. So these are the sorts of risks that you're going to think about as you go through that mapping exercise. So you're going to think about what you put in place, and there are all sorts of templates available in various published sources, and it's the sort of thing that we do and help clients with quite often. But it's for everything from how are we going to manage that risk to who's in charge of it, how often are we going to be checking this, what are we going to do, through to the obvious stuff, the client due diligence, customer due diligence, so CDD and EDD, the enhanced due diligence, where enough of the flags that you've identified that would make that customer high risk for you,
and PEPs as well.
And PEPs. PEPs are automatically a higher risk, aren't they?
And usefully, there is also the UK PEP list.
Yeah.
So the PEP, I've just Cummings PEP.
we're not linked to that, I hasten to say.
Okay, and I should just quickly to add, Serena mentioned sort of communication. It's not just sort of relevant employees, which we'll come to later. This really has to start and end at board level. It's all about somebody who's senior within the hierarchy, so has the knowledge and the experience, but also has the clout to knock other board members and everybody else into shape.
And I think when you're looking at this, and you're trying to work out how you monitor it and how you manage it and how you check every year is a minimum. I suggest that your clients are still the people they say they are, doing the sorts of deals and the transactions and holding the sorts of cryptocurrencies or the sorts of wallets that you trade in, dealing with exchanges you're prepared to engage with, all that sort of thing. You've got to think holistically, and really it's a bit of a sort of Agatha Christie sort of Miss Marple sort of moment of thinking about what it is you want to do and making sure that internally you've joined the dots so that you have something that's proportionate to how big and complex your business is and what you're doing, that you can prove that the decision makers at the top, probably the owners, are tied in and that they are looking at this stuff, and that you write it all down. And the other risk, and that's particularly for those of you that sit outside the FCA pale at the moment, is that, you know, if you can't prove your innocence, you're going to have a really difficult time if somebody comes knocking at your door saying that you're linked to a known criminal or somebody. If you're inside the pale, well, then it's an offence not to establish and maintain your internal policies, procedures, and controls. And you don't want to be going there. FCA is being far more intrusive, and really in many ways rightly so, because there are so many more new opportunities. And if you think about the way in which the criminal mind works, they move into newer, underexplored, less controlled ways of moving and controlling money, which is part of what makes the cryptocurrency world so vulnerable to both allegations, which are more difficult to refute, but also to actual fraud.
Yeah, so just to come in again, that the last line on that slide is in capitals because it is a criminal offence.
So somewhere we definitely don't want to go. So I think the key things, I think I've gone through 2 slides there, haven't I? Yes, I have.
Yeah.
So the key thing I would suggest, regulated or not, appoint somebody. If you're regulated, of course, you'll need an MLRO, a person who will be officially responsible for doing the reports to the board and overseeing the policies, the procedures, the implementation, the checks, the monitoring, and all that stuff that we're used to living with in FS. But also, I think it's really important that you spend enough time training your staff. Now, you've got various options.
Well, it's a requirement, isn't it?
Well, it's a requirement. It is a requirement.
You'll be in an awful lot of trouble if you don't. It goes back to the point about an offence not to have in place the right procedures and policies, and that includes training. So if you don't train staff and record it,
then you can't prove that they knew what they were doing, and you'd made sure that they knew what they were doing.
And we've had this recently as well, haven't we?
Yeah, we have. And I think it's really important that you don't just sheep dip staff with an hour's CBT, you know, on a computer screen with some pick and mix, that you vary how they are trained initially and how they get their annual updates. Because if they were to turn around, and they might, if they were under duress and worried about the security of their job, they might turn around and say, well, it was only an hour on the computer, it was 11 months ago, and I don't really remember much about it, except I was meant to tell my boss, and I told my boss I had a problem, and nobody listened. So I suggest that you muddle up both in your induction training and in your ongoing training, a mix of sitting alongside, of some CBT with Q&As, some engaged sort of, you know, dialogue sessions, some case studies, so that you can show that they were actually competent and you were able to assess their competence and put it in their staff appraisal, that they really understood what they were meant to worry about in sort of, you know, sniffing out whether that client felt right and whether they'd followed the procedures, and they knew where to look for them, and they knew that they were looking at the master version of them. And these are really silly things that so often form a key part of why a 166, a regulatory investigation by the FCA, is triggered, that the firm has not got the capability to prove that the staff actually looked at the policy, the procedures, followed them, that the compliance or allocated checking person, if you're not regulated, actually checked any of the files, and that there was any oversight from the top to make sure it was actually happening. And that's really where that independent audit function, if you're big enough to have one, either an outsourced internal audit or a periodic check, you can just get an external provider to come in and do a one-off and see if you've got it right. Those are ways of protecting yourself and protecting the business and checking that you've got enough in place for the sorts of risks that you feel you are running, having done your end-to-end review process.
I think it might be worth quickly saying that these the 4 things we've got here, including nominated officer, who's the person you report to if you need to make a suspicious activity report. These are all prescribed by the money laundering regulations. So they're here because it's a legal requirement. Turning to the practical enforcement as well, this is something Cummings Pepperdine does quite a bit of training employees, both initially and ongoing, and training very specifically to what it is that's needed. And we also provide this sort of independent audit function as well. We'll talk a bit more about the end. So forgive the shameless selling of our services, but we have been told they're quite good.
And I think what's really interesting is that a lot of the training that's available, a lot of the materials you read are pretty dry, which is why I like the GEM-LSG stuff. Otherwise, you're looking at the rather exciting stories in places like The Sun, where they sort of give it gory details and all.
They are fun. So Daily Mail
they are good fun. The Daily Mail, Money Mail is actually quite a good read. But I think it's really important that you think big enough when you're thinking about the customers and the customer due diligence. And when you think about the non-standard customers who you might need to process, so that you're thinking not just about your standard anti-money laundering, do I know this customer checks. You do the passport, you do the address verification, you probably do the mobile verification. You're doing the different sorts of authentications that are now fairly standard. But actually, you've got to think a little bit more carefully about this. And I think if you've got any risks of connected businesses or individuals who might mean that you are attracting a higher risk type of customer, it is worth making sure that the templates that your staff are following, the questions they're asking, the review processes and the oversight and the sampling even that you are going to do around your CDD, which is the ordinary level of customer due diligence, is robust, even before you get into official enhanced due diligence, which, you know, stuff like the PEPs and high-risk countries and things that, as Claire says, we'll come to. But make sure that the simplified, ordinary client due diligence, standard due diligence in other jargon, there's plenty of jargon for this because it just worries so many firms so much of the time. Just make sure that you've thought about the permutations. So there are all sorts of silly things when you're taking on customers. Are they linked to other owners and controllers? Are they linked through a business? Are they linked to the dual passport, the dual nationality piece? Are they linked to countries where the funds are going to come through to their private accounts and then come into the UK in a way that means that actually the source of funds needs looking at? And you've got to think about it end to end. And that's why I usually come back to building my processes and my controls around GEM-LSG, taking account of the FCA and additional controls are in place, because that way you've got an end-to-end process that gives you operational resilience and protection, which is really, really important for protecting the individuals in the firm. So knowing your customer, the basic CDD, and you're probably thinking, yeah, I have to go through this every time I want to open a new account, every time I want to take on a new service. And so just flip it over and just think about, can I really work out that is the person I'm talking to, or is it a nice photograph they're waving at the ID screen as I'm verifying them on the app? Do you get them to turn so you've got different profiles to see they really are a 3D person? Do you actually follow up and check the address verification? Monzo got a bit of a cold on that one. And then take it that little bit further, depending on what your transaction levels are and the nature of the instruments, the amount of currency you're allowing people to trade into, what you're allowing them to hold, what you're allowing them to transfer out of if you're an exchange into other exchanges, and think about the territories and the traceability. It might be that you've got a traceability within your own product. In other cases, it won't be traceable. So you need to, for your own customers, think about whether what they are doing and what they told you at the beginning they were going to do actually stacks up. If they're suddenly adding extra noughts to their deals, were you expecting that? Were you expecting them to trade every other day, or was it just meant to be once a month? So at your client take on, you've got to ask enough questions that you will understand the transaction and the nature of the transactions, the size, the scope, the territories potentially involved, and why, that you are able to say hand on heart that there was nothing there that aroused your suspicion in the way they subsequently behaved.
And I think it's also worth saying that when it comes to the identity verification, you can use third parties, but there are rules around the third parties, so make sure you use the correct people and so on. And also, if you're part of a group company, it is possible to rely on what other people in the group do to a certain extent. And in fact, the way that group companies should work should be that they're all fully coordinated and they're working from the same basis. So if you're in a group, look at the rules on group companies as well and try and get the efficiencies out of that. Okay, and now the enhanced, it's probably not worth talking about PEPs because we all know.
I think everybody sort of got the idea of PEPs and be frightened of them and hope hope you don't attract too many. Of course, sometimes it's inevitable, and then you just got to have the processes and the controls in place that you know how you want to deal with them. So the key pieces on enhanced due diligence is having enough of a framework in your policies and your procedures that you know and you keep current the jurisdictions and the riskiness factor that are attached to the jurisdictions, so that you know what risks you're running, you know which are complete no-go zones, and you know why particular countries or territories are no-go zones, and that it's not common sense, because actually sometimes it's really counterintuitive, but that you will seek extra information to help you corroborate as much as a sensible person would whether the information you've been fed matches. So if you've got different dates of birth on a passport, you worry. If you've got a transliteration of a Russian or Greek or Chinese or Oriental language into a UK passport, you might need to be more tolerant that this is the same person. If the photographs match, if the address details match, if the source of funds stacks up, you might take the view that the transliteration of one alphabet into another and the name being pretty similar is enough. And I know that when you're getting into checks, that can toss up hundreds and hundreds of people with the same name.
You can get up to you can also get in third party.
The
third party translation services.
And use tech. And also a really old fashioned way of doing it. But when you're looking at passports, get notarized copies, transliterated. So I remember a lovely story many years ago. We had a Russian client in a trust fund, so long time before crypto, and everybody was far too embarrassed to really ask about what this lovely hieroglyphic passport was saying, and relied on it as proof of identity. And when we ran into some troubles a bit later, it turned out, of course, that it was a regional pass for a Russian province, and not at all what we'd relied on as proving the person's identity. And they had a whole selection of them, which they'd been using with other organisations at the same time, and caught a cold, of course, as a consequence. So do that common sense. Is it passing? If you can't get something, if you can't get a proof of address that is from something equivalent to a council tax bill, then think about what is natural in that territory. So if you're a South African, you'll probably live in a housing secure pound, a very nice housing estate, and you might do thumbprint unique identification entry, but the bill from the service provider of your complex would be a good proxy for something as mundane as a poll tax bill. So think about what is culturally the norm, how you could verify it, and what you might need to collect to triage it. And then through your monitoring and security, see how well your metrics, your procedures, your options that you allow your staff to use in order to identify measure up. If you don't like them, tighten them. If you find that you're using an awful lot of time and energy checking them, but only 1 in 100,000 clients ever comes up as a risk because of that trigger, think about what else you could do.
Yeah, and I think also just on the point about the documentation, it's very clear as well in the regulations that if there is any doubt or evidence that the veracity or accuracy of anything, any information that you have is either wrong or in doubt, then you need to consider whether you keep that person as a customer. If it's simplified due diligence, you probably need to go up to enhanced. If it's normal, go up to enhanced. But as we say here on the simplified due diligence, frankly, I just think if you're dealing in anything to do with crypto, it's, don't use simplified. Always just use the standard or the enhanced. I would actually say go for the enhanced, because apart from anything else, if something does go wrong, you can demonstrate you've done everything that you reasonably could.
And I think if you're running well-governed processes and your staff are well trained, you could get this quite slick. You can use quite a lot of tech to support you. Certainly on the transaction monitoring side, you can also get a lot of tech to support you. They can easily be API'd into your own systems. But I think particularly the direction of travel in the UK and the FCA veracity around protecting consumers, even if they're, they appear to be Joe Bloggs, the ordinary Sun or Daily Mail reader. I think you are much safer going to a higher standard and proving that you're operating that in an integrated way.
Yeah, absolutely right. And just finally, I'll just take a bit briefly from Serena here on the record keeping. As I said before, and I know I'm repeating myself, but I can't really say it enough. Make sure that you have records of all your measures, all your compliance control, all your training, and you have them available, not just for the FCA, but you may have to produce them for court as well. Make sure that you keep them for a minimum of 5 years. There's no requirement under the regulations to keep them beyond 10 years. Oh, Lindsay, yes, the slides will be available. Don't worry, we'll be sending those out. And also just make sure that when you're it's not just the sort of the records that you keep, as Serena was saying, you've got to, if they're copies, they've got to be proper copies of this. So if you want a copy, that's absolutely fine, but get copies from solicitors. And when you're dealing with transactions, make sure that all your transactions can be they can be sort of done again. So if the FCA wants to come in and walk their way through a transaction or walk the cat back, all your records are correct and you've got them there. Now, that isn't actually too different, to be honest, from the requirements that you would find under MiFID, AIFMD.
I was just going to say, that's very MiFID of you, Claire.
So, yeah. So, use the FCA as a whole for guidance for keeping yourself safe. And even if you're not FCA regulated or you have no need to be, it's going to help you stay safe if there's a criminal investigation, because money laundering, process of crime, they are criminal. They're not always civil. Okay. Now, just 2 very quick things which apply only to crypto. There are certain things, if we go back and we think about earlier when we talked about the need for crypto asset exchange providers and wallet providers to be registered with the FCA. There are specific disclosures that those people have to make. Now, the FCA is very clear that these disclosures have to be made before you enter into a relationship with anybody. And the thinking behind this really is that the FCA doesn't want anybody to use their name, their badging, their branding as a means of saying, well, use us, you can use us, we're absolutely fine. What they want to say is, okay, you must tell people you're FCA regulated, that's a requirement of the FCA, but also if you're crypto, there are things you've got to do before, and you've got to warn clients whether or not they may be sort of have an additional layer of safety from the Ombudsman or the compensation service, so tell them whether they are or whether they're not. And the FCA do not like you to use them as any form of accreditation. And then finally, again, there's also an addition in the money laundering regs, there's also an additional requirement for reporting if you're into crypto. So again, it's the registered crypto asset exchange providers and the registered crypto asset wallet providers. You have to report on your compliance with large sections of the money laundering regulations. As I said here, it's parts 2 to part 6, and I haven't gone into the details, but in essence, what we've just talked about covers most of Part 2 to Part 6. You have to be able to show how you calculate your charges, because they want to know that customers are being dealt with properly. And bearing in mind that everything is a risk-based approach and that the FCA is a principle-based regulator, they also ask you to consider anything else that might be relevant. So it's another way of them making you demonstrate that you have performed activities which are really about your knowledge of your own business, your client's business, the industry as a whole. So you've got to think about it. You can't just go through and tick boxes. Now, in my blatant attempt at selling, I mentioned to you earlier that we do quite a lot of work with clients where we keep them safe, we get them safe, and we help them if the FCA do come in. We do try and send out quite frequent emails where we track notices from the FCA. If you go onto our website into publications, you can sign up for our PEP points, which we send out every so often, giving people notice of this. And also have a look on LinkedIn, both the Cummings Pepperdine LinkedIn site and also my personal LinkedIn, Claire Cummings. Now, and that's the tracker. Now with the checker, this is actually a bit more of an interesting one. This is a bit like, well, it is, we mentioned earlier, the independent audit function. We have a set of questions and issues to look at, which we've taken from the money laundering regs, the FCA handbook, and also joint money laundering steering group. And we go into people's offices and we go through our sort of the checks and the ones that are relevant and say, yeah, you're okay, you're not okay, this is what you need to do, or yeah, this is where we can help you out. And what we found is that clients have found that a really useful way of making sure that they don't just comply with the regulations if they have to, but even if they don't need to, they've got that external check to rely on. And I don't really need to say much more, do I? You know, having somebody independent to come in with both the legal and the on-the-ground nitty-gritty experience to make things right, you know, it can be very useful. And of course, we can also make sure that you stay up to date and help you with all the FCA reporting. We do have a crypto compliance service, and if anybody's interested in that, we can send you a bit more detail about it after the webinar. So just finally, oops. Have I gone back to the beginning again? Oh, no, okay.
You're there.
This is who we are, a unique firm for the alternative assets industry. And we deal with tax, law, FCA. So the three key pillars are the ones that we deal with.
And Johan, yes, we can. When we come in and we do something like the checker, it depends what you want to do and what your budget is. But if you want us to work through the template, discuss with you and give you an oral report, then we can just do that, quite light touch, some pointers about things you might like to go away and think about. If you want something that is a written report, maybe, you know, group wants it, or you want it on your file in case the FCA come visiting, then yes, we can agree a scope that includes a written report and some pointers for, you know, things to improve, and then we can come and see if you've implemented them in a way that we feel would protect you from adverse comment or scrutiny by the regulator. And you know, the same thing on the training. If you want training materials and a session delivered that you can record and then roll out to your staff the following year, again, that's the sort of thing where we would design it in dialogue with you, mindful of our experiences, the regulations, the principles-based FCA sort of approach, and come up with something that's, you know, size-wise, resource-wise, and time-wise is going to help your business, not be something that's a bit of a burden, but gives you something that is very, very pragmatic and that you can weave into your business as usual without too much effort.
And that's how to contact us. We will be sending round the slides and hopefully recording. Hopefully the recordings worked as well. Holly, our PA, is going to be sort of helping with that. So expect to hopefully get that sometime this week. Are there any other? We said in the advertisement for this that, you know, we'd love to be able to give you some practical tips and so on. So let me just go through the questions here. We are on
So yes, the slides will be available. Yes, the recording will be available because I know some of you came in a bit later.
Yeah.
That's absolutely fine.
And yeah, we do have the check we have, you know, can be written, and we give a kind. Yeah, you're right. We can give that kind of security as a 70 report.
SAS 70 if you want something that formal, which bigger firms often do, particularly
You've
for
done
groups.
actually. You've done a
I've
lot
done
of those
SAS 70.
in banks, haven't
yeah,
you?
I've done a lot of those. So you know, we know what sorts of reports are appropriate for different size and types of organisations, and would give you enough evidence, I suppose, that you know, you could show your auditors, or you could show a regulator, or you could show an investigatory team that came to look about what you had in place and what you'd done to make sure that it was meeting the expectation on standards.
So we've got one chat I can't quite see, but has anybody got any specific questions? Would anybody like any legal compliance regulatory advice that we can help with now? I'm pleased to say that we've managed to come in under the hour. So right, Michael. Michael, I'd love to be able to get you to be able to talk, because I know you do a lot of crypto compliance work together with us. I think you are on mute, and I don't know how to deal with that.
I think it's because of the size of the audience that we've got.
So
if you want to type a message, that'd be brilliant.
Yeah.
And also, if people want to email us and follow up, Jean-Martin, I can see that you've got a question, but it's black on black in the chat. So
just Michael, just quickly say, I know that you, as I say, you do a lot of work with us. What I'll do, if it's okay with you, is maybe add your contact details when we send around an email at the end. I'll add your contact details, so if anybody, you know, if anybody's got anything else that in it they can talk to you about, then they can contact you directly as well. So, right, how can firms deal with a regulatory uncertainty regarding digital asset classification? Do you know what? I don't think they can in any way that gives you certainty, because the whole point is it's uncertain. And as I was saying at the beginning, if you look at the definitions given under the proposed MiCA, you look at FCA, you look at the Treasury, and you look at the Bank of England, it's all different. So my advice to everybody is, if you think you may or may not be within this digital asset space, if you look at the FCA guidance on whether or not you're a utility token, security token, you may not be in, bear in mind that every single one of those is subject to a unique and specific answer depending on the characteristics, and that may change. I think it's about 3 years ago now that Jay Clayton did say he could imagine something, he could imagine a token being regulated, then moving into unregulated, back to regulated. So our advice is always, even if you think you maybe don't need to adhere to FCA rules at the moment, come to us and we can help guide you on whether you do or you don't, and do a guidance note for you, so you can show anybody later, either the FCA or the courts, what you've done, and act as if you are. Always adhere to FCA rules, because you're not going to do any harm by not doing that. If it turns out you do need to be regulated later, you're ahead of the game. If it turns out you don't need to be, but you're adhering to them, and there's some sort of criminal worry, you've shown that you've got there.
Actually, Claire, that's a really valid point. There's a wonderful regulatory phrase called super equivalence, where they read across the standard that one should be aspiring to unregulated or different parts of a business. And what we often find with clients, as Claire says, that products can dip in and out depending on what you introduce and which countries and where your trade and your business leads you. If you work to an FCA standard and you sort of deem yourself super equivalent,
you're going to be okay.
Move in and out quite regularly. But also, if you do need to register, yeah, because the FCA is pretty onerous. But if you need to register, you've already got a track record. So when that application goes in and you say, well, we've been able to do this for, you know, the last X months, years, we've been tracking and following, we've got the policies, procedures, our staff have been adhering to them, then the application is going to go through a green channel, not an amber or red channel. because you've already shown that you have not only aspired to those standards, but you've been seeking to embed them in your business. And that really counts for a great deal, particularly in this space.
And if we could just brag briefly, we can't say very much, but what we can say is that the FCA are looking to improve the times for their applications. And an application we've done recently has been chosen to be sort of part of their trials on how they can improve, because they like the way we put it together. So just quickly, Fiona, if you could just email me those, in case I don't get them from here, then I will add them to the list. And then Vanessa, my view on MiCA and the timeline. Well, it's never speedy, is it? My concern about MiCA is that by the time we've got onto, by the time it comes into force, and it's being delayed as it always is, and it's the same when we were part of Europe as well, it's the same with AIFMD, MiFID II, everything gets delayed. The world will have moved on so fast. And I think that's a result of two things. It's a result of, in a way, trying to get crypto into existing rules, a bit like square peg round hole. The other thing is that regulators by their nature are reactionary more than anything else. So my view on the MiCA timeline is don't expect very much, but keep an eye on what MiCA is suggesting, as well as the FCA. I would expect the FCA to move a bit more quickly, because the UK is now an independent country and it can make its decisions a bit more quickly. I don't think there's going to be a huge amount of divergence between MiCA and the FCA, to be honest. They're still working very closely together on these things, and a lot of the suggested terms within MiCA are very, very much akin to things that we already have in force in the UK, partly because of the European genesis of a lot of our financial regulation. So don't expect too much, but follow the FCA as well, and follow FCA rules. And I think that you will be doing as much as it's reasonably expected that you could be doing. Right, now we've managed to come in under the hour, which I'm pleased to say everybody is going to be happy about. No one wants to talk about money laundering for that long. Not even my own parents would want to hear me. If there are any more questions, please do type now. Otherwise, thank you very much for joining us. We will send out, as I said, we will send out the slides and the recording, and try and follow up with a quick chat as well to see if we can help anybody with any questions. So thank you very much, everybody, for joining. Thank you. Bye-bye.